Thank you, Mr. Shana. With that, I'll call forward the attorneys in 124-920, Shana Jarmer versus Kansas Department of Revenue.
May it please the court, Ryan Gearing for appellant Shana Jarmer. May I please reserve rebuttal?
3 minutes is reserved. Thank you.
Thank you. The issue in this case, Your Honors, is whether my client, Ms. Jarmer, was operating her vehicle or whether she was merely attempting to operate her vehicle. That's important in this case because in a civil administrative license action, according to KSA 8-1002, when we have a test failure, when the person's consented to take a breath test and has completed that, there must be actual operation in order for there to be any suspension or restriction of their driving privileges. The facts in this case are not in dispute. Ms. Jarmer was a passenger in a vehicle that was driven by her husband. He drove the vehicle to the point where the vehicle became stuck in a ditch in some mud, which is a little bit of a different situation than we sometimes see in cases where we're talking about attempted operation. Usually it's a situation where perhaps somebody is out on the side of a country road, law enforcement makes contact with them. They're not in the vehicle or asleep in the vehicle or you know, whatever the facts of those particular circumstances are. But in those situations, there's always circumstantial evidence that the person had driven or was attempting to drive the vehicle by nature of the fact that there's nobody else around. The vehicle got there somehow. And like I said, circumstantially, it appears that person probably is the person who got the vehicle to that point. So given that we know that she didn't operate the vehicle prior to it becoming stuck, we're left with whether she attempted to operate the vehicle after the fact. So when the law enforcement arrived at the scene where the vehicle was stuck, Ms. Jarmer was in the driver's seat. Her husband was behind the vehicle, trying to push the vehicle, trying to get the vehicle unstuck. She was pressing on the accelerator.
And the engine was on.
The engine was on.
Wheels were engaged.
Yes.
Transmission was in drive, her
Yes.
reverse and trying to.
Yes.
Well, why isn't that operating?
I don't believe that that's operating, Your Honor, because by the definitions that have been provided by this court in various cases, and I'll start with State versus Fish, I guess, back in 1980, where this court said operate means drive.
Why isn't that driving?
Our position
Our
is
definition. I mean,
our position is that it's not driving, Your Honor, because the vehicle isn't going anywhere. It's not moving. And I think that's where we get to State versus Kindle, which is a 2002 case. That's after the legislature had added a language to the DUI statute regarding attempt to operate. And this court said that the DUI statute encompasses both those accused of actually driving the vehicle under the influence and those who merely tried to drive but failed. So,
And isn't the intent there though, that she was trying to drive?
yeah, we
The
admit,
goal was to get it out. And so does that intent play into the reason she got behind the wheel?
I don't know that intent matters, Your Honor. I think this is a situation where did she succeed in operating or did she merely try to drive but fail? And we admit that she did. She tried to drive. She just failed. And that's our position as to why this is an attempt to operate as opposed to actual operation.
Your position is that this factual scenario is, as a matter of law, identical to the case where your client gets behind the wheel, inserts the key, and the starter just fails. There may be an attempt, but given the fact that the vehicle didn't move, it wasn't an actual driving.
Right, I would agree with that, Your Honor. The reason for the failure, I guess, I don't think matters. It's
Right,
just
that's what I was getting at.
Yes, Your Honor. Thank you.
Do you think that there's any significance to the fact that under the suspension statute, attempt is insufficient, right? But under the criminal code, it is. And what does that mean? Does that mean anything in terms of how we define operate under the suspension statutes?
Obviously, Your Honor, there is a difference between the criminal DUI statute and the civil statute regarding driver's license suspensions. I don't know that it necessarily makes any difference what we're talking about, because we're still just talking about whether or not somebody operated or attempted to operate a vehicle. And obviously, under the DUI statute, it doesn't matter. Either one is sufficient. But under the statute regarding the driver's license suspensions, the legislature did differentiate. Test refusal, either one is sufficient, just like in a DUI case. But when there is a test failure, they did make that distinction.
You think it has no significance in terms of how our interpretation of the statute, specifically operation, and that we should adopt the same definition that we've applied to the DUI statute?
Yes, Your Honor, that's what my argument is.
Let me ask you this. The evidence in the record, does it show that the vehicle was kind of rocking back and forth?
I don't believe that there was any testimony ever that the vehicle was rocking, or I think the testimony was that the vehicle just never moved. It was stuck to the point where it wasn't getting out of there. The tires were spinning, like I said. The vehicle itself did not move or go anywhere.
So if I'm stopped at a stoplight and that's the only observation of me behind the wheel and I've stopped, engine's running, am I driving or I'm not? I'm not moving.
I would say, Your Honor, that at that point, you are not driving. But for purposes of what we're talking about here today, and especially in this setting, there would certainly be circumstantial evidence that you had driven.
No, forget, yeah, just the only observation is I'm stopped at a stoplight. And then there's, is that driving?
At that
Under
point-
under your definition.
At that point in time, I would say no. But like I said, and it kind of goes back to the example I gave at the beginning, have operate or attempt to operate. And I think under that circumstances, there wouldn't be an argument about whether the person had operated the vehicle, because circumstantially, clearly they'd driven the vehicle to that point
Are you,
if nobody else is there.
are you relying on the language from this court's decision in State v. Darrow
Yes, Your Honor.
that states that operate requires movement of the vehicle?
Yes, Your Honor.
And so my follow-up is, I guess, absent that statement in Darrow, is there anything else in our case law that supports your position?
I would point back, I guess, to State versus Kindle, Your Honor, that talks about, driving, but you're right. Darrow is the case where it actually comes out and says that.
Doesn't Kendall say that nothing in Fish, the earlier case you started with, or other Kansas law, says that the definition of driving does not require movement,
Right.
which is kind of a statement in the negative, which doesn't get us all the way there, does it?
I agree with that, but, and I think.
It's really Darrow.
Right, and that's where we get to Darrow, which, like Your Honor said, it says driving requires movement of the vehicle, and therefore operating requires movement of the vehicle. An attempt to operate means an attempt to move. I think what we have in this case is Ms. Jarmer was attempting to move her vehicle.
Is there any, let's just say for purposes of my question, that upon further examination, that statement in Darrow seems to be overbroad? Is there any stare decisis rationale for sticking with it?
To me, Your Honor, drive means that you're going somewhere, like I'm driving to the grocery store. If I'm sitting in my driveway with a vehicle on, I'm not driving at that point. And I think that's something else that's important is, obviously in this case, the vehicle's on, the transmission is engaged. All of those things are there. But generally in situations where we have people asleep at the wheel or any of these other things, the court has always looked at the fact that the vehicle's on, these other factors as factors in whether the person was attempting to operate the vehicle, not just that you have control of the vehicle and therefore you're operating the vehicle. And also I think that that's important. Another important thing from the Darrow case is that it says that taking actual physical control is insufficient to establish attempt to operate a vehicle without an attempt to make the vehicle move. And we know from that case that Kansas isn't an actual physical control state. Some of the other states around us are. And
Just to summarize, it sounds like you want to plant your flag on Darrow was right.
yes, Your Honor,
And
I think Darrow
there's
was
no
right.
reason to depart from it as opposed to stick with it, even if you have questions about it.
I think that Darrow was decided correctly, Your Honor.
So the operative word is forward, because clearly the vehicle was moving. I mean, the vehicle, the engine, the tires, all the component parts that would be moving if I'm not at a stop sign, but going down the street. All of that was going on, but probably, and I would concede, not going forward. Or let's presume it was not going forward. So it all rises and falls on whether or not it's actually going either forward or backward.
I would agree with that, Your Honor. I think the vehicle has to be moving or traveling, going somewhere. Because obviously if a vehicle is.
I mean, it's doing everything else,
Right.
right? It's just not going forward or backward.
Right. I mean, the vehicle is turned on. Obviously, anytime a vehicle is turned on, there's parts of the vehicle that are moving. And I think that in the cases that we're talking about, the court never says that the parts of the vehicle are moving. It's the vehicle itself that has to be moving in order to drive it.
How about if the car was rocking? I'm actually just envisioning the next case, which is car was rocking, they couldn't get out of the ditch, and the argument that you would be making is, well, it was the husband from behind the vehicle that was making the car rock, not your client behind the wheel gunning the engine, spinning the wheels. And so we've got to make that distinction too.
Sure. And I don't know what the right answer is on that, Your Honor, to be honest with you. It's not the facts that we have here.
You need the chassis to travel one direction, either forward or backward.
Right.
Yeah.
And that's right. Your Honor. Our position is, like I said, I guess the example that I would give is, when I think about driving, it's like, I'm going to drive to gas station. I'm going somewhere. The vehicle is traveling from point A to point B. And whether it's a foot or 10 miles or whatever, we've got to be driving. The vehicle has to be moving. And I think that that's what the intent of the cases that we've been talking about.
Let's talk about the intent of the legislature, because we don't have a lot of definitions here. If she wouldn't have if it wouldn't have been stuck, I mean, the whole point is that, you don't want people who are under the influence of drugs or alcohol to be driving. And in this instance, it was just by the, to draw a line, to plant your flag on this moving. And the fact that we said that in Darrow about the moving, isn't that really, is that really the legislature's intent here? To draw a line on that moving? Is that what they meant?
I mean, it's hard to know exactly what they ever mean, but the only thing that I know is that they did make a distinction. In that distinction, it doesn't, there's no guidance as to why.
Well, wasn't the distinction made because actually, in our case law, I'm pretty sure that in State v. Kendall, after that happened, that's when they amended the criminal statute. These are all in context of criminal statutes.
Sure.
Right. And so they amended the criminal statute, say, okay, to include attempted, because these cases were arising not under the driver's license umbrella, but under criminal cases. So I'm not sure that the legislature's intent to make the driver's license cases different was based on, you see what I'm saying? I mean, we had this line of cases in the criminal
I do,
context.
I do understand I guess the way that I would answer that is, obviously at some point, I don't remember the year, the legislature changed the DUI statute to prohibit both operating and attempting to operate. And given the language in the suspension statute, that statute had to have been written after that because the attempt language is contained in the suspension statute also. So I guess the best way to answer your question is they did make a distinction where people who are attempting to operate a vehicle don't get their license suspended. Purpose of that, I don't know. But like I said, I'm not sure that the reason for the failure matters. I think this just comes back to, did the person operate or did they attempt to operate?
Have we made this way more complicated than it needs to be? We, meaning appellate courts, by really trying to parse through all these various hypotheticals, and why isn't this just a plain question of fact?
I really don't know the answer to that, Your Honor. To me, it seems simple. I mean, it's either you're driving or you're trying to drive, but you failed. I mean, it's one or the other, right? That's the way that I look at this. So when I look at it, to me, it seems very simple, but I understand there's more to it than that. Thank you.
Bradley?
Charles Bradley for Kansas Department of Revenue. Thank you, Your Honors. I guess just to paint a picture for everyone in the room, back in January of 21, law enforcement was called to the scene of an accident wherein a vehicle had driven through a few yards and was stuck in a ditch. Upon arriving, the officers saw that there was presumably a husband trying to push from behind, and the wife was in the driver's seat, revving the engine, spinning tires, etc. I did question, and the officers testified that they did not witness the vehicle propel forward or backward. They did not witness the wheels, the steering wheels turn. They're not saying that it didn't happen, but they were very clear about what they
Clarify that,
witnessed.
it's the steering wheel or the wheels in the ditch?
Both. I asked about the back wheels. I asked about the front wheels.
Fine, okay.
I wanted to
Wanted
get a
clarification.
very clear picture of anything that moved. After they questioned the couple, they believed their statement and understood the husband had driven to the location in order to get it out. Husband gotten back, Ms. Jarmer got in the driver's seat, and they were trying to get it out. And Jarmer was arrested for DUI, produced a breath test of 0.156, and issued the license suspension. Under KSA 8-1002, if a person fails to test, there has to be operation of a vehicle, not just an attempt.
And if the legislature had just added the phrase or attempting to operate, don't even have to stand up at the podium, do you?
I don't. However,
But from a textual point in the statute, just looking at the text, the fact that the legislature didn't add that provision has got to mean something, right?
does. And while I wasn't there for that, generally the intent on that bifurcation is to protect those that decide to, what we call sleep it off. You come out of the bar, you're quite impaired, you turn on your car and you pass out. That is an attempt under the current case law. A person that does that will get arrested for DUI, but won't lose their license as long as they submit to testing. If they're cooperative, if they made the right choice and didn't actually put it in gear, they're probably going to walk away with a diversion.
So, I'm looking at this now and I don't think I noticed this before. So the legislature has made a distinction in driver's license cases regarding the officer's certification, whether the driver failed the test or refused the test. If the driver fails the test, then you got to show operating. If the driver refuses the test, you got to show operating or attempting to operate.
Correct, Your Honor. We have less sympathy for those who refuse testing.
Okay, got it.
Counsel, if I could draw your attention to the language in our case law that I spoke with your colleague about, specifically State v. Darrow. Do we have to overrule that language from Darrow in order for you to prevail?
Not at all, Your Honor.
Why
And
not?
Darrow is a fantastic case. It goes into a lot of explanation about what goes on in a criminal case. However, as explained in Aaron's, there we are. Aaron's was actually before Darrow, but after Kindle. And it kind of helps explain the criminal cases need to be taken with just a bit of a grain of salt, not assault, salt. In criminal cases, it doesn't matter whether there is attempt or operation. So when they discuss a distinction between the two of when does attempt become operation, it's basically dicta. It's not useless. It's logical.
Well,
But
I'll draw your attention to the sentences that seem to stand for a pretty bright line rule that, quote, operating requires movement of the vehicle. Got to move the vehicle to operate it. That's the pretty bright line statement from Darrow.
Darrow also said that engagement in transmission is the last step before driving. Or
I'm just asking you to help me
I
understand how you win when that language is there. Would we at least have to say Darrow was wrong in that limited sense? Maybe we call it dicta, what have you, but
I would say that its application, especially in the instance of 8-1002, which is very specific on operation, is more limited. It's not wrong, but more so that points out what movement and operation is. The court in this case found movement. The vehicle moved in so many different ways. There was just not forward propulsion.
well, there was movement of parts within the vehicle. Is that what you're saying?
Correct.
So I'm mechanically inclined. I like to spend my Saturday afternoons tinkering in the yard. I've got, my hot rod up on jacks and I'm having a few beers and I'm, messing with the engine and I turn it on and I'm revving it up and the transmission's engaged, the wheels are spinning, what have you. And I'm over the limit. Like, did I just violate the statutes?
Actually, that transitions to a fantastic case that I wanted to bring up, the Cullison versus Kansas Department of Revenue. And that one actually matters because it is a license suspension case. In that case, the gentleman was straddling his motorcycle, revving the engine, and he was actually moving back and forward, waddling it. But the transmission was missing bolts. It couldn't even be engaged or used. And in that case, the same Chief Justice that decided the case below us said that's not operation. Because there's no way that this vehicle could move.
How does that, that seems to cut directly against you. Because the analogy would be the mud acts like the missing bolts to prevent movement.
It cuts against a bright line rule. And that's really the main thing that I'm trying to propose today. The rule of thumb that movement equals operation is fantastic for most law enforcement. If you see a vehicle driving down the highway, all right, I can check operation off.
Why shouldn't we just say operate is a common English word? Juries, fact finders, they're pretty smart generally. They understand language. It's a fact question. Leave it to the fact finder.
I completely agree with that. And the fact finder here found that that was movement. And he did so in a very reasonable manner, I believe. But the main thing was that we would like to move away from a bright line rule that says movement is required and movement equals operation, because it doesn't always. You can have operation without movement. You can have movement without operation.
But how does that give guidance to our law enforcement officers out there?
Really doesn't, and I feel sorry. The rule of thumb that movement equivalent to operation would take care of 95% of the cases. This is a very specific case that has not come up before in our case law. Attempt and operation doesn't matter for the arrest at the time. Only distinction is made after the arrest, after the breath test, and whether they're checking off which box on the DC-27. So in reality, this probably isn't going to come up very often. But what I want to establish is that there is no bright line rule for operation, that it needs to be a reasonableness thing. It needs to be based on the fact finder. It needs to be within the discretion of the court to determine, was this vehicle actually being operated, and use all the different factors. And that's what the Court of Appeals pointed out, is that there are a lot of different things to consider. You should look to see, was it the actions of the person in the driver's seat that were operating? Was it outside environmental conditions that were preventing operation? And that was one point that the district court clarified, was that he could not simply find that because of the conditions that the vehicle was in, that being the muddy, soft, wet yard, that these acts on behalf of the driver should not constitute operation of vehicle, movement of the vehicle, and driving the vehicle. Now, I'm sure that the court would love to have a clear definition of what operation is, and I'm sure law enforcement would as well. And like I said, the element of movement certainly helps that.
Let me ask you, I'm still struggling, so I'm looking for something that people can understand. The phrase that's in the Court of Appeals decision, Jarmer was, and then the phrase is actual physical control of the movements of the machinery of the vehicle. Okay. If that's the test, that gets you where you want to be, where the department wants to be. Why not?
Admittedly, because Kansas has intentionally pushed itself away from the term actual physical control. I believe that was referenced because of their, they looked to other states with similar cases to see if their logic was, I guess, congruent. I will point out that they did not rely on these outside cases from Missouri and Pennsylvania as binding precedent. They came to their own decision. And then at looking at similar, almost identical cases from other jurisdictions, they saw, okay, but even though their statutes may be a little different, most states do not bifurcate between operation and attempted operation.
Then how do you articulate the test that the department wants, other than we know it when we see it?
My request is reasonableness and logic. And fortunately, that's exactly what the district court held. It seems like the best definition may be that if a driver engages the engine and the transmission to effectuate and spin the tires, that is operating a vehicle.
Oh, so that was my hypothetical about tinkering in my backyard. So I'm guilty. The car's up on jacks and I'm spinning the tires.
Well, guilty is a term used in the criminal context.
Okay,
and you
well,
would
I've
absolutely be guilty.
violated the statute.
Correct. But the other things that the court had looked at was the implied consent law it's a civil penalty, and it's supposed to be construed liberally for the safety of the public, et cetera. And that was one of the factors that they looked at, was what was the safety of the public at that time? Generally, whenever there's an attempt case, like in Kindle, the guy was passed out, car was in neutral, it wasn't going anywhere. And all three of these criminal cases, the person was asleep. And in those cases, there's only a few steps that the driver has to take in order to put the public at danger. They have to wake up, they have to put it in gear, and they can cause problems.
It's the difference between this scenario and Justice Stiegel's scenario, that he didn't have the intent to go anywhere. He's working on his car versus Ms. Jarmer maybe had at least the intent of getting out of the ditch. Is that a difference? Do we look at that or not?
DUI law has been pretty clearly established that intent doesn't really matter. It doesn't matter if you meant
Right.
drive impaired.
Right.
If you're impaired and you're in control, That's what we're worried about, because we're not worried about, honestly, we're not worried about what you're doing. We're worried about the safety of the public. And when Miss Jarmer was doing what she was doing, the public was already in danger. She was taking all of the actions to put people in danger. The second that that thing gains traction, she's on the road and she's going against traffic. If, unfortunately, the car slips backwards, her husband's under those spinning tires.
Was there any evidence that supported either of those conclusions?
Oh, as in the direction of the vehicle?
No, just that the vehicle
Oh,
could
these
have-
hypotheticals.
could have jumped forward onto the road or could have slid backwards.
No, Your Honor. It was in the ditch, and as they said, that was the intent, was to get it out. But no, that there was no questioning or testimony regarding those issues. Appellant does take issue in its petition for review against some of the out-of-state cases that were mentioned. Again, those are not binding precedent. Those were simply analogous cases that wanted to see if the logic and analysis was congruent.
I have two questions. First, I'm briefly looking at the Court of Appeals opinion again, and it said that when they arrived, the tires were spinning. Was that in the factual record? The tires were spinning?
Yes, Your Honor.
Okay,
But very much so. It was honestly just so sloppy, muddy and cold that there was no forward propulsion.
okay,
That
so the
the
tires
officer
are
did.
spinning. And also the very last paragraph in the Court of Appeals opinion cites to RK State v. Moeller, which is in the context of the Kansas Offender Registration Act. And it looks to the common meaning of the word as defined by Merriam-Webster's operate to mean bring about, affect, to cause to function or work, to put or keep in operation. And they say, using this definition, we agree with the district court's finding that Jarmer operated the vehicle. What is your position on that?
The appellant also took issue with the reliance on Moeller and Mr. Webster's definition. Again, that was yet another example that they used to bolster and affirm their already established conclusion, that they had made their decision.
What is your position? What's the state's position on that? Using that common meaning of the word?
Unfortunately, and generally, dictionary definitions are quite broad. I looked up drive before we got here, and there's a lot of different drives. There's golf drive and football drive, and honestly, those don't go an inch. But I don't think that we should adopt that as a bright line rule. I don't think that there should be a bright line rule for operation and movement. Whenever these cases, these very, very rare, very specific cases come up, leave it to the district court to decide. Was there movement of the vehicle? It is for these reasons, Your Honor. Your Honors, I greatly appreciate you taking this case and reviewing the issues of operation under the implied consent law. Defied appellant's assertion, Cador does not wish to destroy the definition of operation as established in Darrow and other cases, but rather fulfill and clarify it. I pray that this court apply reasonableness and logic when considering operation and uphold the district court and appellate court's rulings.
Questions? Thank you. Karen, your reserve 3 minutes.
I just want to touch on briefly, Your Honors, the statement that counsel made in regards to what he believed that the legislature's intent was for making this distinction in the civil code. And the example that he gave was a person who has had too much to drink and goes out into their car to sleep it off. And what I would argue to this court is that's neither operation or attempted operation. They're claiming that would be violative of the statute. I don't think that that is. And I don't think that that is because of the language in Darrow that says that actual physical control is not enough for operation or attempted operation. There has to be some attempt make the vehicle move to even have an attempt to operate. So at that point, that vehicle is just shelter. That doesn't make any sense to me. So I just wanted to clarify that briefly. And then in regards to, and this was brought up also, the cases that were cited, the out of jurisdiction cases that were cited in the Court of Appeals opinion, in both of those cases, the states that we're dealing with were actual physical control states. So when those courts are finding, and I'll admit that the facts are very, very similar to this case where somebody's stuck in the ditch and the tires are spinning. And in those courts, yes, they found that's operation. And the reason that they found that that's operation is because in those states, actual physical control is operation, which we don't have here. So I don't think that those
Counsel,
opinions are.
if I can jump in, I'm going to ask about one other hypothetical that comes to mind. And if we apply the rule that you are asking us to apply, the Darrow, Collison rule, et cetera, that when you're stuck in the ditch and spinning the tires, but you're not moving, you're not operating. How can you distinguish that, or is there a distinction between that scenario and a different one, which I think is plausible to imagine and seems to me to be obviously dangerous? And that is the drag racing type scenario where you're at a stop, it's fast and furious. You're at the stoplight. You have both the gas and the brake engaged. You're burning rubber, but you're not moving. How do you distinguish? I mean, I'm just thinking in terms of the rule and the outcome. The rule would applied the way you want us to apply it would suggest to me that that person is not operating the vehicle.
I understand the court's question. I guess the way that I would answer that, Your Honor, is I think that circumstance is different.
I know, but how? Under the rule, how is it?
I think it's different because the reason that the vehicle is not moving is also under the control of the person. I mean, in that circumstance, you've got to have your foot on the accelerator and your foot on the brake. This isn't a situation where the vehicle is broken or you're stuck in the mud. I mean, you're trying to drive, but you're failing. In that circumstance, you're intentionally not letting the vehicle move. I think there is a difference in that. I understand the court. I don't know what the answer is. I understand the court's question. We would ask, Your Honors, Miss Jarmer, we fully admit she attempted to move the vehicle. She tried to drive but failed. Under the definitions provided by this court, we think that's attempted operation, and that's what we're asking this court to find. Thank you.
Thank you. Thank you to both counsel for your arguments today. The court will take this under advisement.